A very pleasant day to you. Today, the Employers Consultative Association would like to briefly outline to the public what are the responsibilities and roles of employers in the context of the Occupational Safety and Health Act number 1 of 2004. Employers need not be afraid, they need not panic with the new law. It is simply giving them an opportunity to do what they should have already been doing, but to do it in a formal context as opposed to doing it in an ad hoc context. The law provides rights for employees, it provides duties for employees. The law provides rights for employers and duties for employers, and the law provides for the administration and monitoring of occupational health and safety in the workplace through the Factory Inspectorate of the Ministry of Labour. One area that many employers are quite concerned about is the right of employees to refuse work when safety or health is in danger. This right is enshrined in the law. However, there's a basic process and procedure for this to be undertaken, and it is not to be done in an ad hoc fashion. Once the employers are familiar with that process, then there's no need for fear, there's no need for panic, and it is a partnership between the employer and the employee as well as the union representatives to ensure that what is supposed to be done is done, and that a worker who rightfully refuses to work is not penalized by his employer for so doing. Another consideration that some employers are quite concerned about is the question of penalties, because the law does provide for penalties in the context of monetary fines as well as in the context of jail sentences. However, this law is not intended to put anyone in jail. It's not intended to be punitive. However, provisions are in existence for punishment where the law is broken. The approach is one of cooperation, one of collaboration, rather than one of being punitive, so that all stakeholders need to come together to ensure that the law can be obeyed within a reasonable time frame. Another area that the Act deals with is the area in which doctors are expected to report occupational health conditions to the Factory Inspectorate. If they fail to do so, then they too can be subjected to a fine of up to $5,000 or up to 3 months imprisonment. Again, the intention is not to send doctors to jail, but to ensure that they obey the law by reporting to the appropriate authorities on cases of occupational diseases that are prescribed in the Act. Employers have expressed concern about the plethora of groups and organizations purporting to be running courses on occupational safety and health, and this has caused some confusion both in the minds of employers as well as the general public. Let me say that the Employers Consultative Association does have in-house expertise to provide training in the whole area of compliance with the Occupational Safety and Health Act, and this training is very reasonably priced, and one does not have to spend exorbitant sums of money in bringing your company up to compliance. It is useful to recognize that monies spent on occupational safety and health in the workplace should be considered as an investment in your company and in your workers, and therefore when it is looked at in this context, the provision of personal protective equipment and clothing, the provision of safety boots, safety hats, the provision of training and accident prevention, all of this type of activity are considered to be investments in your most valuable capital, namely your human capital.